Now we are going to look at how statute is structured. A parliamentary statute consists of a number of parts. We are going to discuss those parts one by one. Let's look at number one, short title. This is the example of a Theft Act 1968. This is a short title of the act. Theft refers to the subject of the statute, and 1968 is the year of its publication. Generally, statutes are referred to by their short titles in, for example, cases, textbooks, and journal articles. If the act is referred to frequently in any single piece of work, this can be further abbreviated. For example, TA 1968. Let's look at the next part, citation. As you can see, 1968 chapter 60, this is citation. This is how the act is officially cited. This citation is sufficient to look for this statute, as there cannot be another statute with this citation. This citation could only mean Theft Act 1968. The word chapter may be abbreviated, as we learned before, as C or CH. Number 60 is a chapter number, and it tells us that this is the 60th statute passed in the year 1968. As you can see in the top right hand corner of the statute, chapter number can be abbreviated as CH60. And that takes us nicely to the third point, long title. This is called the long title. Long title gives us some important information about the act and what is it that this statute is about. For example, the long title of this act shows that the act also covers associated offences. This is important, as we know where is the starting point to look if we come across any associated crimes. The long title seeks to provide general purpose of the act as well. And then next point, number 4, date of royal assent, and that is given here, 26th of July 1968. The date provided at the end of this long title is the date when the bill was formally converted into act through royal assent. A statute will usually take effect when it receives the royal assent, unless a different commencement date is given by the statute. Commencement section can be found at the start or at the end of the statute, and the relevant part of the statute is usually entitled as short title and commencement. Point number 5, enacting words. These are the enacting words here of the statute, be it enacted by the Queen's Most Excellent Majesty by and with the advice and consent of the Lords spiritual and temporal, and it goes on. These are the formal words that indicate that the statute was passed after going through the appropriate legislative process and with due authority. Then there are sections and subsections in each statute. The acts contain sections and may also contain subsections. In this example, the main section is section 1. Subsections may be referred to as section 1.1, section 1.2, section 1.3, for example. Subsections are usually intended to deal with different aspects of the same subject within the main section. They may contain explanations, exceptions, and reference to other statutes. Sections can be abbreviated as S, and the subsections can be abbreviated as SS or SS full stop, and they can then be further divided into subsections. For example, main section is 2, subsection is 1, and there is then further subsection, and it will be called as 2.1a. And as you can see in this statute, this explains what is this section about. This is the definition of dishonesty. And there is a further point to make about definitions section. It is not necessary for the statute to expressly state and separate the definitions section. Definitions may simply be added in any part or chapter of the statute. If you look, for example, at this section 10, it does not state this is definitions section, but as you can see, there are definitions, just as we saw in relation to the section which defined dishonesty. This is aggravated burglary. Although this is a definitions section, but it is not stated at the start of the section. It may or it may not. And our next point is about paragraphs within the statute. This is an example of paragraphs 14.1a, 14.1b. Number 14 is the main section, 1 is the subsection, and A and B are the paragraphs within the subsection of the main section. Sometimes they are further divided into subparagraphs. Our next point is marginal notes. As you can see here on the right, extension to thefts from males outside England and Wales and robbery etc. on such a theft. These are called marginal notes, and these notes normally explain the contents of each section. Please note they are not part of the Act and are not referred to by the courts in relation to the interpretation of statutes. So these points, notes, are disregarded when it comes to interpretation of the statutes. Now our next point, which is schedules. Point number 10. The acts may contain schedules at the end. The schedules may contain further explanations or relevant details to the main sections in the statutes. In this example, a schedule provides further provisions further to section 32 of the main body of the statute. States here section 32 and schedule 1 in relation to offences of taking etc., deer or fish, taking or killing deers. And our next point is point 11, preamble. Why I discuss this preamble at the end when it comes at the start? Because it used to be found in the old acts and not in the new acts. In this example, this is the preamble of the Parliament Act 1911 and comes before the enacting formula of the statute. Preamble is an opening statement to the statute and usually seeks to provide the reason for the enactment of the statute. And if you look at the meaning of preamble in the dictionary, preamble means something that walks before. And while we are discussing Parliament Act 1911, you should know that this Parliament Act 1911 is the source of enacting words and enactment formula that we learnt before. It states in section 4 that in every bill presented to His Majesty, these enacting words should be used, be it enacted by the King's most. So this is the source of enactment formula. This is something for your knowledge. And our final point is explanatory notes to the statutes. This is an example of a new relatively statute, Homelessness Reduction Act 2017, Chapter 13, and sometimes they have explanatory notes. There may be explanatory notes that may help the courts in relation to the interpretation of the statutes. They may be prepared by the different government departments or committees. They are not part of a statute. In the case of Kelly and Gray, the Court of Appeal appreciated the assistance that it was able to seek from explanatory notes of a statute. This was despite the fact that in that case the notes specifically stated that they do not form part of the bill and have not been endorsed by Parliament. Please see the example of one of the modern acts, Reduction of Homelessness Act 2017. You will see that this act and the Theft Act 1968 have similar structure. Now our next lecture would be how to read a statute. See you in the next lecture.